Thank you. Yes, it's my pleasure to welcome you all to this first webinar in this four-part series. And the focus of this webinar is public sector corruption. Having listened to Richard Naidu's extremely perceptive keynote speech, it's clearly an issue that warrants particular attention. For those who've just joined us, my name is Gordon Hughes. It's my pleasure to be sharing this session. I'm the chair of the South Pacific Lawyers Association and a former president of both Law Asia and the Law Council of Australia. We have a terrific session planned right now. The full bios of all the speakers in this session are available on the websites of the various host organisations, but let me just very briefly introduce the panellists. And you'll immediately observe from even a short summary of their bios that they are eminently qualified to speak on this subject. And indeed, I think it would be difficult to assemble a more qualified panel. I'll mention the panelists in the order that I think they are to speak. Each of them will speak for just 10 or 15 minutes, and this will hopefully leave us with time for questions. Many of you have already sent in questions and are still sending in questions. So I've got plenty of material to work with, but feel free to send in any more questions as we go. I, of course, can't guarantee that we'll have time to address them all, but we'll do our best. Just by way of overview, our first speaker will be Wiley Clark, who is the president of the Fiji Law Society. He'll be followed by Melissa Pang, who's the president of the Hong Kong Law Society and president-elect of Law Asia. We then have Peter Maynard, who's Vice President Americas of the Commonwealth Lawyers Association and a former president of the Organisation of Commonwealth Caribbean Bar Associations and the Bahamas Bar Association. Then we'll have a recorded address from John Hyde, who is anti-corruption consultant with the United Nations Pacific Regional Anti-Corruption Project. That is a fantastically well-qualified lineup of speakers. Your program also refers to Alan Bakarizi from the World Bank. Very unfortunately, Alan has fallen unwell today and is unable to join us. But we still have plenty of material to go on with. So without me wasting any further of your time, I'd like now to turn first to Wiley Clark, the president of the Fiji Law Society. Wiley?
Thank you, Gordon, and good morning, good afternoon, and probably good evening to some of you. It's my pleasure to be with you today and to have been asked to be part of this panel for this first of the webinar series for 2021. When I sort of had to started thinking about what to say today, I really thought that it's important to at least just break the subject down into two parts and look at it as a question of, first of all, rule of law and how that sits and is operating in our part of the world. But then also then just to touch on the public sector corruption, which is the other part of the subject. And really, if only to, at the end, demonstrate just how critical rule of law is to dealing with this issue of public sector corruption. Now, speaking purely from a Fiji context, when one thinks of the rule of law, we are immediately faced with a challenge that we as a law society are working quite hard and thinking about with quite some in quite some depth as to how to deal with an issue that has arisen, which is that among our lawyers here, we've literally got a whole generation of lawyers that have come through now that don't really understand what the concept of rule of law means. It's already been touched on by Richard and in previous speakers, but we seem to operate under the misconception that rule of law is executive action. It means rule of law, it means executive action supported by laws that enable those actions, and that the written law is mistaken as being the rule of law, and that simply because executive action is being carried out in accordance with with written laws that enable it, that it's all good. Fiji, of course, is not unique in that, and a number of the speakers before have already touched on that. But it is very important to provide that as a context. That's exacerbated somewhat here by a legislative process that Richard's already touched on that effectively excludes the public from the lawmaking process. When it comes to public sector corruption, it's pretty obvious. If anybody is asked what their view of public corruption or just of corruption is that it's going to be negative. Everybody's going to say they don't support it and that it needs to be stamped out. And that's fine. Everybody agrees to that. In fact, stamping out corruption is said to be one of our government's main concerns. However, the critical part that rule of law brings to tackling this issue of public sector corruption is that it brings public trust and public support to any efforts that are made to deal with corruption. This perception and support and trust is critical, because otherwise it's just not really going to work, and any efforts to deal with it are not going to go so well. And so that's where the lawmaking process, I think, becomes relevant. And again, this is a matter that I've already talked about. Richard touched on the two bills that were introduced and passed in Parliament last week, the bill abolishing the assessor system and the bill establishing the anti-corruption division of our courts here. We as a law society called for those bills the consideration and debate on those bills to be deferred, so that a rigorous public consultation and review process could take place, so that Parliament could hear from members of the public and members of the legal profession, including the law society, about what the actual consequence, what really the consequences could be, and whether the laws and changes that were being brought about by these two bills are worth pursuing. And of course, there were going to be diverse views on that, but the point was that there needed to be public consultation, so that the Parliament could be much better informed before they would then proceed to consider and pass these bills, whether with amendments or not. Well, that didn't happen. So those two bills are now law in Fiji. That is a great tragedy in our view, and a missed opportunity, because that has, in our view, by depriving the public of the opportunity to participate in that process, that in our view does not engender much in the way of trust or confidence in the manner in which those in the objectives and the execution of what's going to happen following those bills, those bills coming into law. And of course, we also deal with a context where it almost becomes an annual ritual, where the Auditor General reports are read out in Parliament, and we get about a week's worth of media coverage about the sort of lack of transparency and the not following a procedure and money being lost. And of course, all of these matters that get highlighted by the Auditor General always touch on public sector corruption, but they never get dealt with other than for that first week, and then it just seems to pass until we have it again the following year. And there's also and on the question of perception is everything. So if dealing with public sector corruption is seen as targeted or focused only on particular people or classes of people, that damages the effort and undermines what the overall objective of all of this is, which is to try and deal with public sector. So it's critical that in addressing matters such as public sector corruption, that it is perceived as one where everyone is accountable, everyone, without any sort of favor. And that brings me then to the public service. In our case, I think the manner in which public sector corruption has been dealt with here is, I think, a graphic example of how it can all go wrong. That's because job security is not particularly strong in the public sector, and that's what has generated a reluctance for anybody to make a decision when one is trying to deal with government and getting approvals or just getting a process through government. What you end up with is a sclerotic process where nothing really happens quickly and there's undue delay, or deferring, as we've just found today, on a relatively simple matter. The relevant officer in this, high-ranking officer in this department, referring what is actually a very simple matter to the Solicitor General's office for legal advice. That just adds time. But what this does is create an environment where corruption increases, and an environment where people are incentivized to engage in illegal activity, and in that sort of environment, corruption can it's an environment ripe for corruption to flourish. So these are all concerns to us that I think come back to the importance that rule of law plays, because rule of law properly understood, practiced, and respected is critical to dealing with public sector corruption and dealing with it effectively and dealing with it in a manner that brings the public along with you so that you have public confidence and public support. Thank you very much.
Thank you very much, Wiley. That was excellent and extremely interesting. I'll defer my comments on what you've said or what any of the other speakers have said until everyone has spoken. I might just mention in passing, though, that both the South Pacific Lawyers Association and LawAsia have issued statements in support of the Fiji Law Society in its concern over the passage of those bills using emergency powers. Neither organisation presumed to comment on the content of the bills itself, but they did express concern about the process, which is an issue that you've very clearly articulated. Okay, well, let's move on now to Hong Kong. Yes, to Hong Kong, and hear from Melissa Pang, who's the president of the Hong Kong Law Society and president-elect of LawAsia.
Hello. Hi, everyone. I'm Melissa Pang. Greetings from Hong Kong. Today is still the 7th day of the Chinese New Year, so I'll send a very happy greetings regarding Chinese New Year. Happy to you all, good health and good fortune. First, I have to congratulate the 4 international bar associations for holding this very important webinar. I think it's important for all us to learn and listen to each other. When I look at the issue about the public sector corruption, this very important topic, I would say this is the absence of corruption is a very important part of the rule of law. As lawyers, all of us are duty bound to uphold and defend the rule of law. But regarding the public sector corruption part, I think we have to even look at it on a wider spectrum. Rule of law is not just for the lawyers and the judges. It's much wider than that. Everyone in the society is a stakeholder in it. So it's important for us lawyers to voice out, to tell the public the proper understanding of the rule of law. Another point I would like to make is when you look at the World Justice Project of the Rule of Law Index, you can see absence of corruption is one of the 8 factors of the rule of law. The other factors are constraints of government powers, open government, fundamental rights, order and security, regulation enforcement, civil justice, and criminal justice. But for sure, absence of corruption is a very important part of the rule of law. And today I'm very happy to be representing the Hong Kong anti-corruption regime to share with you our experience. In Hong Kong, we are actually ranked the 11th least corrupt place among 180 places. This is according to the Corruption Perception Index 2020, as complied by Transparency International. And also according to the World Justice Project Rule of Law Index, Hong Kong was ranked number 8 among 128 places in the world in the absence of corruption. And we are the 2nd in Asia. And last year in Hong Kong, the ICAC have done an annual survey findings. We find that 98% of the Hong Kong people said they had not personally come across corruption in the past 12 months. So only 1.6% said they did. And about 99% of the respondents agree that the community is well aware that an integrity environment is paramount to sustainable development of Hong Kong. So we all appreciate the importance of a corrupt-free economy. As these figures show, the corruption situation in Hong Kong is continued to be under control. And we have been acclaimed internationally for our anti-corruption effort and poverty environment. And here I would like to outline some of the factors behind. The first one is the rule of law. We all must agree the rule of law is the fundamental pillar of the integrity system. It is the cornerstone of good governance, and it is an indispensable element of the successful fight against corruption. Rule of law also serves to lay a solid foundation of impartiality and equality in society. As I mentioned before, absence of corruption is one of the 8 factors in assessing whether a country or territory is adhere to the rule of law in practice. And according to the Rule of Law Index 2020, Hong Kong was ranked 16th among 128 countries or jurisdictions. Let's look at another factor. It's about the anti-corruption law in Hong Kong. In Hong Kong, the main anti-corruption law is the Prevention of Bribery Ordinance, It's aimed to enforce against abuse of entrusted power or official position by public officials. And the law prohibits corrupt behavior involving conflict of interest situation of different gravity, ranging from accepting restricted advantages in private capacity without permission to bribery involving abuse of official power and possession of unexplained wealth. When we look at the relevant section which regulate the conduct of public servants, there's a number of sections. In brief, the section 3 will say no prescribed officer is allowed to solicit or accept any advantages. Section 4 says any public servant who solicits or accepts any advantage as an inducement to or reward for performing duties will be guilty of an offense. And in section 6, it says any prescribed officer who maintains a standard of living or has assets not commensurate with his official emoluments shall be guilty of an offense. Also, we have another ordinance, which is the Election, Corrupt and Illegal Conduct Ordinance. The most important, another important common law offense, which the Hong Kong empower the ICAC to do investigation, is the misconduct in public office. This is a common law offense, and we rely this in many cases of investigation and prosecution. And we do have judgment in our Court of Final Appeal back in 2005, who clearly set out the elements of this common law offense. So there are 5 elements. It must be a public official. The second element is in the course of or in relation to his public office. Third element is the public official willfully misconduct himself by act or omission, for example, by willfully neglecting or failing to perform his duty. And the fourth element is without reasonable excuse or justification. And the fifth element is where such misconduct is serious, not trivial, having regard to the responsibilities of the office and the office holder, the importance of the public objects which they serve, and the nature and extent of the departure from those responsibilities. And in Hong Kong, we have a very important body, which is a famous Hong Kong ICAC, which is the Hong Kong Independent Commission Against Corruption. The ICAC was set up back in 1974. This is the one and the only anti-corruption agency in Hong Kong. It is dedicated to enforcing the anti-bribery laws, advising the government and private sector organization on how to plug system loopholes, and promoting public awareness to fight corruption and entrench a clean culture in the society. So you can see the function of ICAC is the first one is to do investigation and prosecution. And the second one is to engage in the preventive part of it. And the third one is to promote public awareness on how to fight corruption. Here, we would like to also emphasize that on the constitution and legal basis, the independence and the statutory mandate of ICAC are guaranteed by Article 57 of the Basic Law. Article 57 provides that a commission against corruption shall be established in Hong Kong. It shall function independently and be accountable to the chief executive. And on the section, okay, I want the slide before, thank you. And on Section 5 on the ICAC ordinance, the commissioner must be subject to the order and control of the chief executive. And it is not subject to the direction and control of any person other than the chief executive. So the importance of this is the constitutional and legal safeguard guarantee that ICAC shall function independently. So if this function is ICAC shall report directly to the chief executive. And on this slide, you can see ICAC is taking a three-pronged strategy. The first one is the operation department, which considers and investigates corruption practices and offenses. And the second one is to the prevention part. This is important that ICAC will examine practice of various government departments and public bodies so they can reduce the risk of corruption. I think always think of this like this way. Prevention is much better than the cure. So before it happens, it's important to look at the system of various government departments as well as public bodies to make sure their system is functioning well and there won't be like loopholes for people to take advantage of. And the third part is the community relations department, which will educate the public about the evils of corruption. And the public will support ICAC in combating corruption. So we always see prevention as a very important deterrent effect of having any corruption in society. The following is just a procedure of the ICAC investigation. I think I'll skip that one. The next point I just want to comment is about international engagement. I think it's very important for Hong Kong to be engaging with international stakeholders so that we can foster cooperation and learn from each other. And on this slide, you can see Hong Kong actually, as China has ratified the United Nations Convention Against Corruption. And the convention has been extended to Hong Kong in 2006. And the Hong Kong ICAC is designated to assist other signatories of the convention in developing and implementing corruption practice. So it's, you can see that even in Hong Kong, every year, around 3,000 visitors will come from other jurisdictions to come and do exchanges. And I think these days, they also do the exchanges on web through webinars. And also, that's very important that there'll be like international and mainland liaison and mutual assistance. Nowadays, we can see that corruption has become more cross-border crime. And ICAC is maintaining liaison with anti-corruption agencies in other jurisdictions. And also, experience sharing is paramount. ICAC is an active member of a number of international organizations, including the International Association of Anti-Corruption Authorities, Asia Pacific Economic Cooperation, and also the Economic Crime Agency Network. I think for sharing experience and information, it can help all countries and jurisdictions to combat corruption. And also, there's like strong partnership of Hong Kong business chambers with the ICAC set up the so-called, it's called the Business Ethics Development Advisory Committee, of which Hong Kong Law Society is also a member. So we join hands to promote business ethics to community and international enterprises. I think the time is up. Okay, I thank you for your attention. Thank you.
Thank you, Melissa. That was extremely interesting. And one thing that's coming through loud and clear is that the eradication of corruption in public office is a fundamental element of the rule of law. It had been my intention to not raise any questions until everyone has spoken, but I just got one specific question that's come in to you, and Wiley might also have a comment on it. It's just a request for further information. The question is, does the Hong Kong judiciary system have specialised courts dealing only with corruption offences? Are assessors involved in High Court corruption trials? And the questioner asks, I ask this in light of the fact that Fiji's Bribery Act is a copy and paste of the Hong Kong Bribery Act.
Oh.
Do either of you have any any thoughts on that?
No, actually, we don't have specialized court in it, but we do have because it's dealt with by the criminal courts. So I think people have the specialty that we judges with specialized expertise in the area. So there's no worries on that. Yeah, and I think normally depends on which court it go to. In the High Court, I think normally it's with jury.
Thank you. Okay, we'll get back to you, Melissa, when everyone else has spoken. I'd like to now move on to our next speaker, Peter Maynard. Goodness knows what time of the day or night it is in the Bahamas at the moment. But Peter, as I mentioned in my introduction, is Vice President Americas of the Commonwealth Lawyers Association and a former president of the Organisation of Commonwealth Caribbean Bar Associations and of the Bahamas Bar Association. And we'll be very interested to listen to what he has to say. Peter?
Thank you so much, Gordon. Good day. It's actually 1:38 a.m. Here in the Bahamas, but it's worth it. I mean, this is really awesome, this collaboration among the four organizations. And I look forward to many more sessions like this. I've really enjoyed the inspiring address by Richard Naidu, as well as the insightful comments of Wiley and Melissa. But let me say, it's an honor and a pleasure to have been asked to be a part of this distinguished panel. And thanks notably to the whole team, Stephen, yourself, and the whole Chung Wan, and the Shana, Magda, and the whole team, who were so very helpful. I also, as Brian pointed out, Nassau, Bahamas looks forward to sharing with the CLA, the rest of the Commonwealth, and the Caribbean in September. So do please be part of that event if possible. I'm going to talk about two things and perhaps bring a different perspective: the nature and impact of public sector corruption, and secondly, some asset recovery tools and war stories to provide some context and hopefully a different perspective. Let's see. Every dollar that a corrupt official or corrupt business person puts in his or her pockets is a dollar stolen from a pregnant woman who needs health care, or from a girl or boy who deserves an education, or from communities that need water, roads, and schools. A quote from the World Bank president. Indeed, it's a real tragedy, particularly affecting women and children and the poor generally. And standing up to corruption, we know of the events in Tunisia, for example, and also affects countries like Kyrgyzstan. Corruption threatens the governance, development, stability, and security of societies. It undermines the institutions of ethics and justice. So, I'm sorry, I'm going the wrong direction. Slides. Oh, did I lose it? Oh, I'm sorry. I think have I lost you? Let's see if I can get back the PowerPoint back. Oh, I'm sorry. Sorry about that. There are huge challenges involved, and the effects are felt across state boundaries. This makes redress and recovery harder. Money moves faster than victims, and sometimes fraud is a low priority event for law enforcement. There are quite a number of major treaties. We know that, and indeed this seminar webinar is timely because of the UN special session coming up from the 2nd to the 4th of June of this year. And hopefully countries such as ours will contribute. I have a special affinity with the South Pacific Islands where I spent some time. And so I do hope they participate in the UN session along with countries, smaller countries like those in this region. And so we have treaties extending from the 1997 Inter-American Treaty to UNCAC. And then much has been built on top of that, as pointed out by Melissa in her comments regarding Hong Kong, for example. And so there are quite a number of major institutions which have been formed. I'm quite happy to provide a copy of this to anybody who would like to have it. There are also major networks of government agencies and civil society. In particular, the very last one, FraudNet of the International Chamber of Commerce. I happen to be one of a group of 70 or so persons around the world under the auspices of the International Chamber of Commerce who focus on asset tracing and recovery. Indeed, as again pointed out by Melissa, Hong Kong does very well in terms of the scoring. It's one of the top scorers, the Transparency International, and the bottom scorers include Cambodia, Afghanistan, and North Korea. And the countries are arrayed again. On one hand, Indonesia not doing particularly well, and on the other end, Myanmar doing, and South Korea, or rather North, and indeed not doing so well either. So everybody in politics needs money. And so there are some of the 25 colossal corruption scandals ranging from Siemens, for example. In Germany, a huge amount was involved there. A wise judge, actually from Australia, once said to me, people don't follow politicians, they use them. And indeed, some politicians pander to the worst instincts of constituents and lobbyists, and ultimately to their own worst instincts. We have the case of Sani Abacha, Nigeria, 1.3 billion was recovered, and not long ago, an additional 321 million was recovered. Of course, we know of the 1MDB scandal in Malaysia. Increasing the odds of recovery. One of my preferred areas of practice is concerned primarily with civil recovery of assets for victims of corruption. Recovery requires 24/7 responsiveness and collaboration with a global network to investigate and take action against fraudsters. In appropriate cases, access to financial assistance is required. The methods involve legal counsel, investigators, and forensic professionals as a team, and also stealth and speed to move diligently. And one obtains gag and seal orders as well as investigative orders. The strategy may include managing cases across many jurisdictions, deciding where to bring proceedings and also how and when. Specialized tools include letters rogatory. For a time, I was the legal advisor of the Ministry of Foreign Affairs, and we dealt with many letters rogatory and also developed many MLATs. We also now have available other institutions such as financial investigation units, and one relies on, for example, disclosure orders and NORC bankers trust orders, and the 28 US Code 1782 for disclosure. but also super injunctions, also known as interim non-disclosure orders, prohibiting reporting on the fact of the proceedings, and they're given in rare and exceptional circumstances to maintain the effectiveness of the court and to prevent tipping off. The gag and seal closed hearings gagging are used very widely in these kinds of cases. Many of them are not remain under seal, as you'll see in some of the examples I shall give you. One also has to lift the corporate veil in many instances to get at the persons behind companies which are used as a facade or a sham. One of the cases I've dealt with, this must perhaps a decade ago, involved CDR Créance and Safra International Bank and Trust. This was a French government agency which loaned money to a family called the Cohens. They bought, among other things, a hotel off Times Square in New York. And we were able to secure disclosure, giving a paper trail leading to assets in many jurisdictions, notably Spain, Florida, New York, and Switzerland. Leadenhall Bank and Trust, there was a Ponzi scheme called Cash for Titles. It had some impact upon political figures as well. The debt arose out of a default judgment, and we were able to obtain a judgment for $330 million on behalf of 1,100 investors. Recovery is also made separately in Bermuda, and a dividend in excess of $14 million was paid. The winding up of a bank, we have to anonymize these cases because so many of them are still under seal. The applicant got an order to retrieve documents and computer records. Provisional liquidator was appointed, and again, we were able to secure and seize records and establish a paper trail to other assets. A company in liquidation involved a transfer of some 120 million to accounts worldwide. The liquidator was able to recover assets. We recovered, for example, a luxury condominium near Sandy Port, the Bahamas, which was sold, and the assets were returned to the liquidator. In this case, a bankruptcy estate was appointed in Helsinki, Finland. The trustee was recognized as a trustee within the Bahamas. With the help of financial investigation units in both countries, we found 2 bank accounts. And that's the interesting thing of this case is we involved not only action in a common law action in the Supreme Court, but also government agencies, in particular, FIUs. Initially, the FIUs had frozen the proceeds, the accounts, and we were able to convert those accounts, or those freezing orders to civil freezing orders. And in the end, a sum of 266,000, and in another case, approximately 1.3 million were recovered and repatriated to the trustee. A more recent case, a former Bahamas Electricity Board member was convicted in 2015 of receiving a bribe of $220,000 to steer contracts to a large French multinational to purchase, in order for the government to purchase generators from them. About $75 million were paid in bribes to government officials around the world, including Indonesia, Saudi Arabia, Egypt, Taiwan, and the Bahamas. The Connecticut court ordered the company to pay $772 million, the largest criminal fine under the U.S. Foreign Corrupt Practices Act at that time, for falsifying its books and failing to implement adequate internal controls. Regarding suing politically exposed persons for corruption, the prospect often fizzles out especially when the new government leaders reach the mental block of there, but for the grace of God go I, or they are unable or unwilling to finance legal proceedings, or all of the above. Lack of political will is seen repeatedly as one of the stumbling blocks to effective asset recovery. Solutions, there's no panacea. One size does not fit all. I refer to the need for greater transparency and cooperation, increased resources to regulatory agencies, expanded collaboration among civil society organizations, and hopefully these can be espoused during the upcoming session. And indeed, the ills referred to by Richard and also by Wiley, hopefully they can be addressed in the context of this kind of international collaboration. So thank you very much.
Thank you very much, Peter. One thing we miss in these online seminars is you don't hear a round of applause for your efforts afterwards, but I'm sure there would have been. That was very insightful in terms of, I think, explaining how corrosive the effect of public sector corruption can be. And I like some of your quotes. I wrote down a couple as you went. Money moves faster than the victims, I thought was quite apposite. And some politicians pander to the worst instincts of constituents. They just appeal to me. We'll be back to you, Peter, if you can stay awake for just another half an hour. And we're going to move on now to a recording of a presentation from John Hyde. John wasn't unable to be with us at this time. John, as I explained earlier, is an anti-corruption consultant with the United Nations Pacific Regional Anti-Corruption Project. Has some very interesting things to say. This recording goes for exactly 5 minutes, and please stay with us.
Good evening and welcome from the United Nations Pacific Regional Anti-Corruption Project. I'm John Hyde, a consultant with the project. I would have loved to have been with you in real time this evening, but I'm currently facilitating some training with the newly established Solomon Islands Independent Commission Against Corruption. The UNPRAC project is involved with all 14 of the Pacific Island countries. It's a joint UNDP and UN ODC project, and the goal is to promote and strengthen measures to prevent and fight corruption more efficiently and effectively in the Pacific region. And it's aligned very much with the United Nations Convention Against Corruption, UNCAC, and also the spirit of the Sustainable Development Goals, particularly number 16, which is related to access to justice. Our project aims to support the Pacific Island countries to strengthen their national integrity system, but to also support a stronger engagement of non-state actors such as the media, civil society, the private sector, MPs, in the oversight of corruption. And the project responds to requests from the individual 14 countries, and we're working towards effective, transparent and accountable governments promoted and with an enabling environment for trade, business, investment and sustainable development. We're assisted by DFAT from Australia and New Zealand Aid through their MFAT project. Now, if we look at the international framework, first of all, in the Pacific, that's largely through the United Nations Convention Against Corruption. If we look at the regional level, we've got a number of frameworks. The Pacific Forum's 8 Principles of Accountability, the very important 2018 Boe Declaration on Regional Security, and a number of others. But probably the important one for us was the Te Anywha Vision, which just 1 year ago in Kiribati, the last major Pacific conference before COVID closed down the big regional Pacific meetings. And this was in terms of Pacific unity against corruption, held in Kiribati, and it led to an implementation roadmap called the Te Anywha Vision. And just 2 weeks ago, the Pacific Islands Forum, in its last meeting, adopted the Te Anywha Vision as the regional combined approach to anti-corruption. Again, we look at the Boe Declaration, which enshrine with it when we're talking about regional security, that you've got to be addressing transparency and corruption. And very much in terms of the Sustainable Development Goals, we see SDG 16 in terms of being an overall goal, that you can't have climate change unless you have integrity, unless you're addressing corruption. You can't have health, you can't end poverty, unless you're addressing the issue of corruption. Now, one of the ways that governments throughout the region address corruption is through developing a national anti-corruption strategy. And the joy of the Pacific is that every country is different. And while many are based on a Commonwealth rule of law, they have very different levels of implementation as we go from a very populous country such as Papua New Guinea down to Niue, which on a good day has got about 1,600 residents in total. And while there's no single best way to develop a national anti-corruption strategy, there's a number of key ways that we go about helping countries to implement. And a big part of it is making sure that you're able to implement. We do have a lot of commitments made in the Pacific. Implementation, of course, is very important. Now, let's have a look across the region. We find that all the Pacific countries, the 13 independent countries, have all now adopted and signed the UN Convention Against Corruption. Now, if we look at them having a National Anti-Corruption Committee, and many people also look at the issue of whether there's an independent commission against corruption. Most of the states in Australia now have one of those. I was very much involved with the setup of the West Australian Corruption and Crime Commission. And in the Pacific, we have Fiji with a well-established independent commission against corruption. PNG has just legislated and has had an interim one. Solomon Islands has established and is now implementing theirs. Tonga, 2007, passed legislation to establish an independent commission against corruption. It has not yet been implemented. But then we look at small countries, and we've worked with Kiribati and Samoa, who wanted to investigate the idea of, okay, we've got an issue with corruption. Is having an independent commission against corruption the way to tackle it? And what consistently comes up is when particularly smaller countries look at it, is that you're actually getting a more effective way of being able to deal with public sector corruption and also private sector corruption if you're actually strengthening the existing integrity agencies, your ombudsman, your auditor general, your police service, others who have a responsibility with corruption. And across the Pacific, there's some different models. In the Marshall Islands, the Auditor General's Office is in effect a de facto anti-corruption commission. It's done some quite extensive and excellent investigative work. It works hand in hand with the police as well. So in many ways, it's doing the work that you'd see in a well-established, well-funded anti-corruption commission in a much larger country. Solomon Islands has not only established an anti-corruption commission, but it's also introduced freedom of information legislation as well, and whistleblower protection is also on the agenda. So there's other instruments apart from the U-Butte independent commission being established. But those that are established do need assistance, and they need oversight, and they need the community and, of course, lawyers such as yourselves who are working with them or working within their frameworks. We're addressing a lot of these issues on a regional level, and UNPRAC has a number of books and further information, holistic integrity frameworks, where we're looking at the combination of governments, private sector, CSOs, media, parliamentarians working together. And of course, as I've said, all the countries are different and their assistance needs are different as well. But it's a fascinating area, and because we've got all 14 countries now signed up to the UN Convention, that's providing a framework for them to be concentrating on the implementation of anti-corruption strategies, anti-corruption legislation, policies, and what's really needed to tackle corruption and promote integrity. Thanks very much for your interest in this topic. And I enjoy very much being able to look at my fellow panelists this evening and your questions as well. I'm delighted to provide this short presentation to you. And at the UN Pacific Regional Anti-Corruption Project, we're more than happy to provide you with any additional information. So thank you, Tomas. Thank you very much, Vinaka. Goodbye.
That was a terrific presentation, and I wish John was with us live so that we could thank him personally. I'm hoping Melissa is still with us and can turn her camera back on, because I'm now going to make Peter and Melissa earn their keep, because Wiley has been called away. John's on video, Alan Baccarese is sick. That means that Peter and Melissa are going to be fielding all the questions. Now, in fact, we've got so many questions we can't possibly get through them. I'm just going to throw a couple at you and see if you have any comment on them. And there may be some that are not relevant to your sphere of activity, which is quite understandable. But I'll just throw them out at random, and any comments you might like to make about these questions, I think the audience will be extremely interested in. The first one is this. Is there evidence that countries with anti-corruption agencies experience less corruption, or are they just better at weeding it out? Do either of you have an observation to make in that regard? I'll repeat it. Is there evidence that countries with anti-corruption agencies experience less corruption, or are they just better at weeding it out? In other words, what is the impact of anti-corruption agencies?
Yeah, an excellent question. I think the jury is still out on that, the impact of anti-corruption agencies. In countries where there is poor governance and high corruption, it may be very difficult to establish an independent, a truly independent anti-corruption agency. And so it may have limited impact. I've seen references to studies where there was uneven or insufficient financial support given to the agency. Also, weak institutional mandates were issued. And as a result, one has to take a very holistic approach to make sure that the context is supportive of an independent institution.
Thank you. Melissa, you're on mute.
Yes, Gordon, I think we have to go back to a bit in the history. Maybe I can share the situation in Hong Kong back 1974. That's a long time ago. That's like 47 years ago. I think I'll say half a century ago, before the ICAC was set up in Hong Kong. Corruption is a very major issue in Hong Kong. In the 1960s and 70s, there are many movies made about those era. People have to take a backdoor route in order to earn a living or secure some even basic services. Let me give you some examples. At those times in the 1960s, if you go to hospital and you are a patient, maybe want to ask for a glass of water in the hospital, you have to pay the hospital owner a licence or some tips in order to get a glass of water, or even maybe jump the queue to see a doctor. So that were in the 60s, early 60s. And also many people in Hong Kong, they accepted it's like a tradition, like tea money, black money. People have to give tea money to others so that they can carry on with their life, maybe even getting a job. If you try to get a job, you pay some licence or tea money to maybe the manager in the company. So those were the days when corruption is quite prevalent in Hong Kong. And also corruption is very serious in the 1960s and the 50s within the police force in Hong Kong. There are corrupt police officers. They offer protection to gambling and drug activities. And it all happened back in 1973. At that point of time, there was a very famous police superintendent. He was involved in a bribery scandal. He, just as a humble police superintendent, in the 1970s, he controlled assets over 4.3 million Hong Kong, which is like around $7,000 in US dollars, $7,000, which is a huge sum of money in the early 70s. So at that point of time, because there's a scandal regarding bribery, he just left Hong Kong and took an early retirement and went back to the United Kingdom. And there was a review report on that incident. And it was pointed out that if we have to get a responsible body to convince the public that the government really want to fight corruption, we had to set up anti-corruption office, which is separated from the police. That's the background of the setup or establishment of ICAC in Hong Kong. So ICAC was set up in 1974 because of all those background in Hong Kong. At that point, when it was set up, it reported directly to the governor. And so it's separate from the police department, which was quite corrupt at that. So after that, this independent anti-corruption organization, ICAC, was established in 1974. And since then, I think the Hong Kong community, they have the overall education and publicity to clean Hong Kong up in terms of corruption. And I think overall, Hong Kong people are very proud of the work of ICAC because they have done a good work. And I must say that everyone is equal before the law. Even a couple of years ago, as many can recall, the Hong Kong, back in 2017, even our former chief executive, Mr. Donald Tsang, he was convicted of an offense of misconduct in public office in the High Court, although the offense was later quashed because of technical ground. And also back in 2014, our second man in government, Mr. Rafael Hui, which is the former Chief Secretary for Administration. He was arrested on suspicion of corruption, and he was sentenced to 7.5 years in prison. And he returned bribes of over 11.8 million Hong Kong. So I would say, like, in Hong Kong, everyone knows that the power of ICAC, and everyone is equal before the law. No one is above the law. And even the existing regime, there are provisions which regulate alleged corrupt acts of chief executive, especially that common law offense of misconduct in public office. Yeah, I think I'll rest my case. Thank you.
Thank you, Melissa. Terrific answer. Thank you both. I'll just go on to the next question at random. Why is corruption more rife in third world countries than in developed nations? Any insight?
I don't agree with the premise there necessarily. In the case of many, let's say the United States, for example, lobbyists are very, very effective. A legislator may have to follow high-profile issues because that ensures their electability. But there are many low-profile issues, hardly noticed, which don't determine whether or not that person is elected. And as a result, lobbyists have a great deal of influence over those kinds of issues. And so there are different forms. There is the dark money of elections, campaign financing. There are the unincorporated associations in the UK. It's hard to trace where their money come from to finance campaigns. There are also super PACs in the United States. Very hard to find out where their financing comes from. And so I don't, it's obviously there is a more developed institutional structure and more resources, but there is no limit to the ingenuity of people who wish to engage in corruption. And so there may be changing forms. You know, for example, COVID-19 procurement seems to be an issue for many developing countries. These emergency laws suspend due process, and as a result, one is not quite sure where the funding comes from or where it goes to construct new hospitals and to bring in supplies and so on. That may be more characteristic of developing countries, but on the other hand, we have the campaign financing issues. For example, we have the allegations that President Trump used the White House as a family business, so to speak. And so these are all forms of corruption.
Thank you. Melissa, do you want to add anything to that?
Yeah, I think I haven't got empirical study on that, but I think like corruption is very important to, first I would say education of the public on that is very important. Because I think in some society, they might have the practice or of like giving some tea money, etc. But I think like it's important to educate about the evils of corruption, and it's important to enlist public support in that. Of course, I would say it's important for an institutionalized organization to be set up, so it will have full force in doing like education of the public, doing investigation, and also like prosecution. And I think it's important to have the combination of both of it, this education and investigation and prosecution in order to clean up corruption.
Thank you. Each of your responses has preempted the next two questions. The first one I'll sort of throw principally at Peter, because I think you've already answered this question. Does corporate influence contribute to public sector corruption? Does corporate influence contribute to public sector corruption?
Yes, I think most definitely. The huge resources of the companies have a big impact. For example, I refer to the case involving the French multinational corporation, which is supposedly spent millions of dollars around the world, including, I listed the countries, Saudi Arabia, Indonesia, the Bahamas. And the objective was to buy contracts, to influence the decision-making. In the Siemens case, for example, the fabulous, the well-known German company, during their time, they having a fund for corruption, a slush fund, was considered a cost of doing business, actually budgeted for at that stage. And so certainly the companies can have a very large impact upon corruption. At the same time, the other side of the picture is that companies should go to great lengths now in the interest of corporate social responsibility to avoid being stigmatized and involved in corruption. And of course, we have legislation such as the U.S. Foreign Companies, Foreign Corruption Act, the SCPA. And there one must do a due diligence exercise every year practically to make sure that one conforms with the regulations. And so that's a positive development in the sense that companies are buying into developing a stronger anti-corruption regime. But there are some very notable examples of companies which take a different point of view. There's a case of the Icelandic company which needed a fisheries contract in Namibia, and they were prepared to spend huge sums to corrupt officials who had control over the fishing, allocating the fishing rights. That's been exposed. And so one still finds instances where companies exert huge amounts of influence to obtain contracts.
Thank you. Melissa, do you wish to add to that?
Yes, Gordon. I think it's just like in a dance or in a tango, it takes two to tango. Whenever you're talking about a public servant, if they accept an advantage, there must be the flip side. Someone must be offering the advantage. And normally it could be from the business community or the business enterprise. And in Hong Kong, it's very clear. For the public sector, for the public servant who accept an advantage, he will be guilty of an offense. And on the flip side, any offerer of the advantage shall also be guilty of an offense. So it's someone offering, someone accepting, both are guilty. I think when we talk about this point, I think it's very important, go back to public education. Of course, the enforcement of the law will have a deterrent effect, but it's also important to build up the ethical stance of for the businesses. Yeah, thank you.
Thank you. Now, the other issue which I said was preempted this time by your previous response, Melissa, and I might try and make this the last question because I'm feeling so sorry for you both. being interrogated like this. Melissa, in your previous answer, you referred to, if I understood you correctly, the practice of tea money. And one of the questions that came in was, is there a cultural issue where customary gifts might be confused with bribery? Is that something that either of you have had cause to contemplate?
Interesting. I don't see this as an interrogation for me, rather just a sharing. Let me give an example. I think at the moment it's still okay, like for like when you have dinner with some official, you can still have dinner with them, but they cannot. For example, you have a very big meal, big banquet. I think it's for consumption per se, it's okay. But that's one example. If you have a very expensive Chinese abalone on the dish, the government official, they can consume and eat the abalone on the spot, but they cannot take away that abalone home. That will be considered as taking an advantage. And also on like Chinese custom, even for the private sector, for example, we're going to a certain club, they will say, no license for the staff of the club serving you. But on certain, maybe if the employer is giving a blanket exception during the first 10 days of Chinese New Year, just like today is the 7th day, if I go to like Hong Kong Jockey Club, I'm allowed to give a small sum of license which is tea money, to the staff, with because they got the for the private sector, if the staff got the consent from the employer, they can take on those tea money, but not for public sector. So we have to be very careful, because nowadays people are very careful about not breaching the relevant legislation.
Peter, thank you.
Yeah.
Peter?
Yeah, I totally agree with Melissa. A little to add on that, except to say that so when they are very small amounts, it may or may not be petty corruption. There are codes of conduct which public servants should follow. Some are required to declare gifts of a certain value, or perhaps generally. I think those codes of conduct are very important to regulate that kind of area.
Thank you, Peter. I could sit here all night listening to this because I'm finding it fascinating. I'm under strict instructions not to go beyond time. And so I'm going to just start to wrap up. But in doing so, I just want to mention 2 questions that I'm happy to answer myself, which I think are relevant to what we've been doing for the last hour and a half. One question was, are there challenges in developing a vibrant law association in South Asia? And my answer to that is they already exist. And I think if you look at the international organisations associated with this seminar, they are 3 examples, the 3 international associations, of vibrant law associations, each focusing on a slightly different demographic, but which are very effective, and all they need is the continued support of lawyers in the region. The other question I just wanted to mention in passing was, is there a link between poor disciplinary regulation by bars and the emergence of national corruption? And my response to that is, come back and tune in on the 11th of March, because that's basically the subject matter of our 4th webinar on the role of law associations in combating corruption. I'm going to wind things up now, and I want to start by, well, first of all, I apologise to everyone who's sent in questions which couldn't possibly get to answer. We might have to do this all over again and just get through more questions because